Hi and welcome. I'm really glad you're here. Today, we're diving into something that's really important. It's how to make sure that your family stays out of court and out of conflict if something happens to you. I'm Kelly Balamuth. I'm an estate planning attorney. I'm also a mom and a wife and a grandma, even. And I'm honored that you're spending your time with me here this evening. I really believe that knowledge is power. And it's my hope that the information you're going to learn today will really empower you and that you'll walk away with tools, with clarity, and a powerful first step toward real peace of mind. And I want you to know that your time here today is really well spent. Stick with me until the end, and you'll receive something pretty special, a $750 planning session, completely free, plus a $250 credit toward any legal plan if you end up booking today. So it's a $1,000 value that I'm gifting you for being here. And then, just from a housekeeping perspective, like we said a minute ago, I'll be taking questions at the end. So if a question occurs to you while I'm talking, please jot it down, and that way we won't forget it. You could also put it in the chat box if you want. But first, I want to ground this talk in something personal, and that is who needs your protection? If something were to happen to you, who would need your protection? For me, it's my kids, my husband, my two grandkids, and even our dog, really. Um, and so write this down if you're taking notes. Who are the people or the pets that you love the most and want to protect? This might be your children, your spouse, your nieces and nephews, maybe cousins even, or maybe a business partner or a business. If something were to happen to you, who needs that protection? Go ahead and jot that down. I'd like us to sort of anchor in that together. And just to get to know a little bit about you and where you're coming from, if you wouldn't mind typing this into the chat box. And that is who here currently has an estate plan. That could be having a will, a trust, or some legal document in place to protect your family or your business. You could drop it into the chat box, what you have at this point. I would love to know. Mm, hold on one second while I get myself organized. Here we go. So we have one person who doesn't have an estate plan, which is totally a fine way to be and not uncommon. If you don't have an estate plan, you're not alone. 62% of adults don't have any estate planning documents in place whatsoever. And if you're talking about only the adults with minor children, the percentage of those adults without an estate plan is even higher. If you do have an estate plan, it's important to have it reviewed every 3 years to make sure that it stays up to date and protective because things change. Your life changes, the law changes, your assets change. And so it's important to make sure that your plan stays up to date over time. If you've ever thought of any of the following, you are in the right place today. That I'm too young to worry about this, or it's probably really expensive, or I started something online, but I don't know if it's enough. And if you have a plan already, maybe it's out of date and you're not sure if it'll really work the way you want it to. You're absolutely in the right place for that as well. At the end of the day, an estate plan isn't actually about you, it's about the people that you love the most. Your spouse, your children, your business partners. They're the ones who'll be left to figure things out when the time comes. And so this is part of what we help families do. Really take care of it, leaving no stone unturned and making sure that loved ones aren't confused or caught off guard later. So let's make sure they're not left confused, stuck, or in court. Before I jump into talking about the meat of what we're going to talk about tonight, I just want to briefly tell you a little bit more about who I am and why I'm so passionate about estate planning. I've been an attorney since 1994. I went to law school at UC Davis, and when I graduated, I became a trial attorney. For 25 years, I was battling for my clients in court. One of the things I've really loved about being an attorney is helping my community, helping people who have had tragedy befall them get help. But doing trial work, the pattern that I saw over and over was that tragedy would strike unexpectedly, and people didn't have access to the legal tools we're talking about here. And as a result, their loved ones were in court and conflict, sometimes for years. So I became really passionate about helping families gain peace of mind before something bad happens. Because by the time you're in a situation where you have to go to court, you're relying on strangers, a judge, or a jury to decide things for you that are often life and death situations. It's like gambling, and it can really make you crazy. So much about estate planning is the opposite of litigation. We don't go to court, we don't have to worry about strangers making important decisions for you. It's simply all about what you want and avoiding problems in the future. And we don't have to go to court to do that. In fact, most of what I do is put plans in place so to keep people out of court. So the reason that I do these seminars, my why for all of this, is that I've watched a lot of clients who were injured or family members of people. Hold on, I have to admit a couple more people. I'm so sorry. Multitasking. Um, yeah, I've watched a lot of clients who are injured or family members of someone who was killed unexpectedly have to navigate being stuck in probate court, either because they didn't have an estate plan or the plan that they had failed. Being stuck in probate court can cause a lot of conflict. It can tear families apart. And seeing that made me passionate about making sure people don't have to go through that. That's how my firm is designed. And that's why I do these events, because I really believe that knowledge is power. I've received a few accolades along the way that I'll just briefly share with you. I've been recognized as a super lawyer many years running, and a few times named one of the top 50 women lawyers in Northern California. And Avo, which is a website that rates lawyers, has given me a 10 out of 10 rating. So that's just a little bit about me. Now we are going to meet the Bliss family, a fictional family that's about to go through five heartbreaking but kind of eye-opening scenarios. And each one is going to teach you something that could spare your own family a ton of pain. So let's jump in. Let me introduce you to the Bliss family, a beautiful blended family. Mark and Molly are happily married. Their children, Benjamin, who's 12, Caroline is 10, and Molly has a teenage son from her prior marriage, Alexander. He's 15. They have joint checking accounts and they're putting money away for retirement. They both have life insurance and make sure that their financial resources there if one of them were to pass away. And they both came into the marriage with a little bit of savings already. They each have a solely owned investment account. And in Molly's solo account in particular, she also has an inheritance from her parents who have passed away. But they've never needed to touch that money. So Molly's inheritance is still sitting in that account. Now, Molly, she has an ex-husband named Xavier, and he is, shall we say, he lived fast and he wasn't the most supportive dad. But he did do one responsible thing. He bought life insurance. He bought a life insurance policy, but now that he and Molly are divorced, he obviously doesn't want his $1 million policy payable to Molly, his now ex-wife. He wants it payable directly to his one child, his son, Alexander. So Xavier made that update on his life insurance policy for Alexander to be the beneficiary of his life insurance policy. Honestly, if you ask Molly, this is the one responsible thing Xavier has done in his life, having a life insurance policy at all. So that brings us to sad day number one. Xavier is turning 40, but that is not why this day is sad. This is his big birthday. He wants to do something he's never done before, and he's decided he wants to go skydiving. So on his 40th birthday, he steps into the plane to go skydiving. But he's just so excited that he doesn't pay attention to the safety instructions. And before you know it, he's jumping out of the plane without a parachute. So all of a sudden, we have a skydiving scenario gone bad. Adios, Xavier. Xavier has no estate plan, remember. Although remember, he did that one responsible thing in his life. He bought life insurance. So what happens? Xavier's gone. Alexander is just 15 years old, and he is now the beneficiary of a $1 million life insurance policy. And he is thrilled. He's already dreaming of the red sports car he's going to buy. But Molly, his mom, is understandably worried. He's 15, she says. He's not ready for that kind of money. She calls our office, and what do we have to tell her? We deliver the bad news to Molly that we have to go to probate court to figure out who is going to be in charge of the $1 million until Alexander is an adult, meaning 18 years old. Because Alexander is a minor, he can't legally own or control money. So the court has to appoint a conservator to manage the funds until he's 18. As part of the process, we have to submit Molly's credit report and background check to the judge, which she considers invasive, but she has no choice because the judge doesn't know who Molly is, and he wants to see these things to make sure that she's a responsible person. By the way, everything about this court proceeding is public record. That means that anyone can search it and find out what's going on and find out that Alexander is going to be receiving a lot of money. And it takes time because we're on the court's timetable. Molly assumes, as Alexander's mom, that she'll be the one chosen. But guess who else shows up? Xavier's brother, Zachary. And he doesn't think that would want Molly, his ex-wife, managing these funds. So now it's up to a probate judge, a stranger, to decide which one of them gets to control the money. So here's the twist. There's no law that says that the surviving parent gets to be the conservator, and there's no law that says a blood relative of the deceased person does either. So the judge doesn't know any of these people. They'll review background checks, credit reports, even question Alexander in court because he's over 12 years old. And then at age 18, Alexander is going to get the full $1 million with no restrictions, no guidance, no oversight. So it's kind of interesting to think, I think, like, what would I have done if somebody had handed me $1 million when I turned 18 years old? I'd like to think I would have invested it, but I'm pretty sure I would have blown it, gone to Vegas, done something really stupid. So, what if Xavier had tried to be smart and said, I'll just name my brother Zachary as the beneficiary instead? He thinks this is an easy, quick way to fix this. Lesson learned, don't name a minor as a beneficiary. But here's why that won't work. Because if Zachary is the beneficiary, it's Zachary's money, as simple as that. If Zachary wants to use the money for Alexander, great. If Zachary wants to use the money for Zachary, for himself, also great. He gets to decide because it's his money and he can use it for Alexander or not. And because it's Zachary's money, if Zachary goes through anything in his life where he might owe someone else money, maybe he owes money to someone who sues him or a creditor or an ex-spouse or something, then because Zachary has ownership of all this money, someone else who Alexander doesn't even know can garnish the money directly from Zachary, leaving nothing for Alexander. Then Zachary is completely out of luck. So, what if Xavier instead had created a simple will that said, I leave everything to Alexander. If he's under 21, Zachary's in charge. That sounds better. But because in California, two things override your will, it is still not a solution to our problem. In California and most states, two things override your will, and that is joint ownership and beneficiary designations. Joint ownership means when you own property jointly with somebody. If you own property as a joint tenant with right of survivorship, it's a legal term, that means when they pass away, you immediately take over their ownership interest. That happens before a will ever comes into place. And beneficiary designations, which tend to be really common on like life insurance policies or retirement accounts, you name a beneficiary that gets the money in your account or in your policy when you pass away. Those beneficiary designations and distributions happen before we ever look at a will. So in this case, the life insurance already had Alexander named as a beneficiary. And so that overrides the will. That means that even though Xavier has a will now, before we even get to reading the will, $1 million is left to Alexander. So once again, we're back to court. And just to be clear, even a valid will goes through probate. That's why we see the wills of like John Lennon or JFK Jr. or Babe Ruth or Larry King. It's because probate court is public. So even if Xavier had a will, Alexander's money still goes through the court and the judge still has the final say. And if someone leaves no will, guess where we have to go? Still to the probate court. Everything going through probate requires legal notices to all the parties involved, even if a family member is disinherited. And if you've ever had to go through probate for a loved one, this might sound familiar. As I've worked with a lot of families in the past, I've found there's this assumption that a will solves every estate planning problem that you can think of. And while it's absolutely critical that you have a will, it's definitely not the only piece of your estate plan that you need. Now, if you're wondering, what do I do if what do I do if I don't want my loved ones to have to go to court? That idea brings us to idea number 3, which is here's what Xavier should have done, which is create a revocable living trust. He should have created a trust, named Alexander as the beneficiary of that trust, and appointed Zachary as the trustee of the trust to manage it until Alexander is older. And then, and this is key, he updates the beneficiary designation on his life insurance policy to say that it goes to the Xavier Family Trust. Now, when Xavier falls out of that plane, the $1 million check is made payable to the trust, not Alexander personally. And Zach deposits it in a trust checking account and manages it on Alexander's behalf exactly how Xavier wanted. no court, no delay, no make sure it pass it. That's called trust, and that's that your assets are. Okay. Hi, are you all still here?
Yes,
Oh, good. I had a
I thought
little
it
internet
was.
issue. I'm
I
so
thought
glad
it was
you're
my
still here.
computer.
Huh?
I thought it was my computer.
No, I think it's my computer. I'm afraid I have having an internet issue, but thank you so much for staying. And I'm just going to dive right in and keep talking, and hopefully we won't continue to have problems.
If anybody's streaming, that could happen.
Yeah. Oh, like anybody else in our house?
Yeah, if they're watching Netflix on TV or something and they're streaming a show or something, it could slow down your internet.
Okay. I want to put all of you on hold for 10 seconds while I go in the other room and make sure that my husband isn't streaming. I'll be right back.
You're welcome.
Okay. Thank you all. We're going to get through this together. Okay. So here's the first major takeaway of our bad day number one. And that is that a legal document isn't enough. You need to review every single asset and make sure that it's going to pass the way you want it to. That's called trust funding, which is making sure that your assets are properly titled to your trust. And it's the most important part of having a trust. It's really counterintuitive because the moving your assets into the trust happens after you create the trust. And traditional estate planning firms don't really help with this aspect of it. Um, it's really important. It's the most important part if you have a trust in your life is to make sure that your assets are titled to it properly. So let's move to sad day number two. What happens when parents of minor children are unexpectedly incapacitated and the wrong person shows up to care for the kids? The Bliss family heads up to Tahoe for a long ski weekend. They're having a blast, blue skies, fresh powder. The kids are in ski school. And joining them is their longtime friend, Dina, who really loves the kids like they're her own. But then the weather turns and a fog rolls in, visibility drops, and Mark and Molly, who are skiing fast down the hill, collide with each other hard, and it's bad. They are airlifted to Tahoe Forest Hospital. Meanwhile, the kids are waiting at ski school. Dina Dina is planning on picking them up and bringing them home. A first responder finds a photo of the Bliss family in Mark's wallet and they realize that there are minor children involved. Dina calls Molly's sister Mindy in Texas and Mindy jumps on a plane, but it's going to take hours for her to arrive. So, can Dina step in to help the kids? No. Dina is not a blood relative, and without legal documents, that means she has no authority. The default under the law is that only adult blood relatives can be temporary guardians. So what happens? The kids may be taken into protective custody, a complete stranger's care, while the system waits for someone legally qualified to show up. So if you're a parent of minors, to me, this is one of the scariest questions because what is happening is going to be really scary for the kids. Children don't know what's going on, they don't understand who the strangers are. And so we want to make sure that they're going to be in the care of somebody that we totally trust, who we know will love them, and ideally somebody that they know and recognize. So let's do something better for the Bliss family here. This is why we build short-term guardianship plans into our estate planning. Mark and Molly could have signed a simple document naming Dina and others as trusted short-term guardians. It's fast, it's clear, and it works in emergencies. And with that plan, Dina could show a digital copy of the document on her phone to police or first responders. She could keep the kids safe and calm, and no one would get taken away, no confusion, no trauma. So, quick sidebar. Let's not forget about Rio the dog and Whiskers the cat, the Bliss family pets. They're home with a pet sitter who has no idea what happened. The pets are barking and meowing for days, and the neighbors could get frustrated, and eventually animal control might show up. So even pets need a plan. We can include pet care instructions and even designate caregivers in your estate plan. In fact, for all of my clients who have pets, I put together a little pet protection plan for them, which is not really legally enforceable, but it just records feeding instructions, who the vet is, who to call in an emergency. Because if you don't come home, your pets need somebody there. So here's lesson number 2. Estate planning isn't just about what happens if you die. It's also about if you're hurt or missing. Your minor kids and even your pets need clear, fast plan for who steps in immediately and not eventually. That brings us to sad day number 3. Mark recovers from the ski accident, but Molly doesn't. She's unconscious at the hospital. Mark is making Molly's decisions for her despite the emotional burden of the whole experience. Mindy, Molly's sister, who flew in from Texas, she wants to know what's going on, so she calls the hospital for an update. But the doctor says, "I'm sorry, we can't give you any information due to HIPAA laws." Mindy's furious. "I'm her sister," she says. But the law is clear. Without written permission, no one can access your private medical information. You might assume Mark, Molly's husband, has the sole right to make medical decisions for her, but he doesn't. Under the law, any interested adult can be involved in those decisions, whether it's your spouse or not. So now Mark and Mindy are co-decision makers, and if they disagree, it's back to probate court. While all of this is happening, medical bills are coming in fast. Mark tries to access Molly's personal savings account to help pay for them. It's her inheritance account, only in her name. He goes to the bank with their marriage certificate and explains the situation. The banker says, "I'm sorry, you're not on the account. We can't help you." Even as her husband, he has no legal authority. So now Mark has to go to court again. He has to prove to the judge that he's financially responsible, that he's the right person to make decisions, and that his sister-in-law, Mindy, shouldn't have an equal say. Remember, he's doing all of this while he's trying to support his injured wife and take care of the kids. So this is a nightmare for the Bliss family. Let's do something better. All of this could have been avoided with 3 simple legal tools. With Molly's medical power of attorney, Mark would be able to solely make Molly's medical decisions, even if Mindy was there in person. Now, Mindy, of course, can have very opinionated views and be as loud as she wants about any disagreements with Mark. But at the end of the day, legally, Mark has the final say-so, and we don't have to go to a probate judge for permission about that. Under Molly's HIPAA release, Mindy can call the doctors and find out what's going on. If Mindy is named on the HIPAA release, even though she's not Molly's medical power of attorney to make decisions, all a HIPAA release means is open communication. And most importantly, Mindy has a copy of the HIPAA release that she provides upon the doctor's request. Remember how important copies are, like we had with the temporary guardianship forms. With the financial power of attorney Molly signed as part of her estate plan, she names Mark as the sole decision maker regarding her finances. This means when Mark walks into the bank, he can bring the financial power of attorney with them, and he can get access to that account to pay Molly's medical bills. This is a huge time saver because instead of having to go to probate court, Mark can immediately take this document and act under it and do it for Molly's benefit, which saves him a ton of hassle and a ton of time. So lesson number 3 is that if you don't choose who makes decisions for you, the court will. And often it's not who you would have chosen. These documents are part of every estate plan that we create, and they protect you not just when you're gone, but when you're still here and vulnerable. Okay, that brings us to sad day number 4. Despite everyone's hopes, the doctors deliver the worst news, which is Molly's injuries are irreversible. Mark, her husband, and Mindy, her sister, are faced with the impossible. Should they remove life support? But without legal documents, that decision doesn't belong to them. It belongs to a probate judge, a stranger. So think about this. Would Molly want to be kept alive for 5 days, for 30 days? Not at all. Without her voice in writing, everyone is just guessing. Mark says she wouldn't want to live like this. Mindy says, no, we have to keep trying. She could recover. They argue, they cry. Eventually, a decision is made, but it's painful and it leaves scars. And now Molly's gone. Alexander is now an orphan. Mark, his stepdad, steps up. He says, I've raised him. He lives with me and his siblings. He shouldn't have to move. But then comes in Alexandra, who is Xavier's mom and Alexander's grandmother. I'm his blood. He's my only grandchild, she says. So who should the court choose? Mark isn't Alexander's biological parent. Alexandra's not young anymore. Neither is an obvious default. So again, the judge decides. And the result? Someone who's already lost everything, his mother and his father, is now in the middle of a tug of war. This was avoidable. Here's a better way. Molly had a plan in place. She named Mark as the legal long-term guardian of Alexander. No confusion, no court battle, no trauma. And because she went the extra mile, she even wrote a letter to the guardian asking Mark to maintain Alexander's close relationship with Alexandra, his grandma. Now Mark knows what Molly wanted, and Alexandra knows that she'll still be part of her grandson's life. So let's talk a little bit about assets now. Molly had a vacation home in Lake Tahoe. It was hers alone after her divorce from Xavier. And when she passed, guess whose name is still on the title? Molly Bliss. To change that, the family is going to have to go to probate court. But here's the catch. Molly lives in California. The Tahoe home is in Nevada. So that means two separate probate court proceedings in two different states. Two lawyers, two judges, double the court filings, double the time, double the cost, and all of this for the property that the family just wanted to keep and enjoy. So what if Molly had a trust? Remember when we created the trust for Xavier? This would be the same thing. She could have transferred title of the Tahoe home to her Bliss family trust, and that would have been no probate, not in California, and no probate in Nevada either. Just a simple, seamless transition of ownership, private, efficient, and totally court-free. One of the main reasons that people want a trust is to avoid probate because it's a very expensive and time-consuming process, and it's kind of the last thing you want to put people that are grieving you through while they're grieving you. So here's lesson number 4. You don't get a second chance to make these decisions. Once you're gone or incapacitated, your voice is either in writing or it's gone. Every day you wait is kind of a gamble, not just for your family's finances, but peace of mind, for relationships, and for ability to grieve without chaos. Okay, now we're at final sad day number 5. Many years later, Mark is older, grayer, and he passes away peacefully. After everything he went through with Molly, though, he still hadn't finalized his estate plan. So now his adult children are calling our office. But the first thing we have to talk about, it's not who gets what. It's not family memories. No, first we talk about the IRS. Let's talk for a minute about Prince. When he died, his estate was worth $300 million. So how much of that do you think went to the IRS? 30%? Half? 100 million? It was $120 million. Why is that? Because the estate tax is real. The IRS defines it as a tax on your right to transfer property at death, which is charming. But there's a bit of good news for most of us. Right now, the estate tax only applies if you have more than $13.99 million, and that's per person. So if you're in a couple, it's basically $14 million per person that you can die with tax-free. So most families don't need to worry about that. But that number, the state tax exemption, it's controlled by Congress, and it's set to drop down to around 6 to 7 million in January. But the current budget bill before Congress would keep it at its current rate. So we're sort of in this no man's land right now, not knowing exactly what's going to happen. But if you don't have $7 million or more, it's really not something you have to worry about. But if you do have more than the estate tax exemption, anything over the exemption amount is taxed at 40%. So it's pretty dramatic. So after taxes are paid, what's left goes straight to Mark's kids. And here's the thing, it goes to them outright. No guidance, no protection, no accountability. They're thrilled. Vacations, new cars, business opportunities with that friend from college. And just like that, their money is gone. What if Mark had left that inheritance in trust to his kids? It could be protected from divorce, from lawsuits or creditors. It could be managed by a financial mentor or trustee until the kids were ready to manage it on their own. And it could be distributed in stages after college or after a job or after they've showed some maturity. It's about creating structure, support, and protection, not just leaving money, but like leaving wisdom. This is part of what we help people do, is figure out how not only to leave their wealth, but their wisdom as well. And let's not forget about Rio and Whiskers. Now that Mark is gone, they need care too. But don't leave money directly to your pets. They can't walk into a bank, they cannot inherit anything. Instead, you can leave instructions and a small fund to a trusted caregiver in a plan so that you make sure that they're cared for. So here's your final core takeaway. The government gets paid first, your family gets what's left, and they get it however you decide or fail to decide. If you don't build a plan to guide them, protect them, and support them, you're handing them a windfall with a blindfold. You deserve better and they deserve better. So let's zoom out for a minute. We've talked about legal documents, probate, guardianship, court, and chaos. But when your loved ones think of you, they're not gonna frame your will and put it next to their bed. They're gonna want your stories, your values, your memories, your voice, really. That's your real legacy. That's why, as part of our planning process, we help clients capture this in a recorded legacy interview because who you are matters just as much as what you own. And it's really what people miss when you're gone. So now I invite you to remember why you're here. Turn back to what you said when I asked who needs your protection. What would happen? I'm sorry, if you found yourself during this webinar asking yourself, what would happen to your loved ones if something happened to you? Today, there are a lot of options for estate planning. Whether you work with an online service or even a lawyer, you can easily get a set of documents in place. I regularly see the problems created by do-it-yourself or what I call documents-only plans, and so I don't ever recommend that. But before I give you next steps, I want to say something important, and that is sort of where I get honest here. There are a lot of ways to get documents done these days. You can go online, you can use a DIY service, or even get a lawyer to crank out a basic will or trust. That's what I call documents only. And honestly, if you're just looking for paperwork, I'm probably not the person for you. In fact, I'll go a step further and say if all you want is to check a box and feel like you've done something, we can actually point you to a free service to create a simple will. So you could just email me after the webinar and I'd be happy to send you that link. But the truth is that I've seen play out again and again is that people who rely on documents alone usually leave a mess behind. Not because they didn't care, but because they thought documents were enough. We don't just create documents at our firm, we really build relationships with families and we create plans that work when you need them most. The truth is, estate planning focused on documents only creates a false sense of security and often leaves your loved ones with a mess. At our firm, we believe that what you truly need goes beyond mere paperwork. It's about fostering a meaningful relationship. You're not just looking for a will or a trust, you're seeking a comprehensive plan that supports you throughout your life and continues to care for your loved ones after you're gone. That's why we've shifted our focus from simply providing documents to creating lasting partnerships with our clients. We take the time to understand what's truly important to you, to really understand your family dynamics and your assets and how the law applies to both. This clarity allows us to craft a plan that not only meets your legal and financial needs, but also reflects your personal values and your goals. Our firm offers a family care program, which is a yearly membership program, and this is how we continually ensure that your plan stays relevant and effective throughout your lifetime. We offer regular check-ins to update your plan as needed, along with substantial discounts on future changes. So this ongoing support, it really ensures that your plan not only meets today's needs, but also adapts to your future circumstances so that your family knows what there is, where it is, how to find it, and how has someone to guide them in what to do. Our process begins with a 2-hour working meeting where we clarify your current assets and your needs and help you choose the most effective and affordable plan for you and your loved ones. We're committed to providing you with a plan that works now and in the future. And so I want to do something right now. In your own mind, ask yourself, am I the kind of person who values doing this right, not just cheap? Do I want my family to have a clear plan, not just a pile of papers? Do I actually want helping getting this done? Not more homework I won't do. If your answers are mostly yes, then we should talk. And if not, that's totally okay too. This webinar is meant to educate, not pressure. But the opportunity I'm about to share is really for people who are ready to do something about this and want professional guidance to do it right. So if anything I've said here today has you thinking, would my assets be lost to the government, or what would my family have to go through to take care of my affairs? Will they be able to find what I have and know what to do, or will they be lost and confused? I want to support you to know that you're doing the right thing for the people you love, and we do that with a life and legacy planning session. This is a 2-hour working session where we sit down together, either in person or on Zoom, and you tell me about your family dynamics and your assets, and I tell you about the law so that you'll know exactly what would happen to the people that you love. Then you'll tell me what about that works for you and what doesn't, and together we choose a plan that's best for you, the most affordable, effective, and efficient. My fees for creating a comprehensive estate plan, they range from $3,000 to $11,000, with most plans falling between $4,000 to $6,000. And if we create a plan for you that includes a trust, the cost starts at $5,500. I understand it's a significant investment and it's natural to seek ways to economize, but truly when it comes to estate planning, choosing the least expensive option can often lead to greater costs down the line. It's not just about drafting documents, it's about ensuring peace of mind for you and the security for your loved ones. And it's about crafting a plan that holds up when it's needed most without ambiguity or legal loopholes. So think of it this way, really. While everyone loves a bargain, some purchases like a parachute or a life vest are really worth investing in for quality. Normally, a life and legacy planning session costs $750 because it's a comprehensive 2-hour working meeting where we really accomplish a lot together. And if you sign up for a life and legacy planning session in the next 24 hours, not only will the session be complimentary, meaning no charge, but you'll also receive an additional $250 credit toward any future planning. First, it's important to know who this session is ideal for. If you're interested in documents only, I'm not the attorney for you. If you're a DIY type of person and you aren't worried about your kids or future divorce or getting stuck in a court process or about your loved ones knowing what to do and what there is and where to find it, if you don't have concerns about those things, then DIY is probably the way for you to go. But if any of the stories that I've shared today made you recognize that you need a personalized consultation to avoid leaving your family in disarray, or if you know you're just not the kind of person that's going to get this done on your own, then an appointment with me is a great idea. If you're committed to your family not having to go it alone, then you should come in. These appointments are designed for people who want the comfort and the security of knowing that loved ones will know what to do if something happens to you. So if you've attended today and are considering booking a session, we'll waive the usual $750 fee if you commit to completing some homework before the appointment and turning it in before the appointment. And if you book your session in the next 24 hours, I'll also give you a $250 credit toward your ultimate plan. So that's a total value of $1,000 in legal services for taking proactive steps for the people you love. Now, if you already have an estate plan and you think you might want to have that reviewed, I'm happy to do that. I charge $950 for that review, and I don't waive that even if you do the homework. But we sit down together in the same way. I get really in the weeds with you about your family and your assets and your current plan. And if we decide there's any work that needs to be done, then the $950 is a credit toward any work we might do. So that's if you have a plan already. But if you're new to planning, then with the homework, the planning session is complimentary. The biggest risk to estate planning is procrastination. Our entire business is set up, the systems are set up to overcome procrastination, and that's why I offer this $250 credit. If you prefer not to book in the next day, we'll still waive the $750 planning fee, but the $250 credit is my effort to get you to move forward on something that I think you need to move forward on. I reserve 2 hours of my time exclusively for you, and I limit the number of clients I can see each month. This is a working meeting with an attorney about your personal situation. Finally, if you're married, both of you and your spouse should attend the appointment. I say that I do these seminars because I believe that knowledge is power, and that is completely true. But if I'm really honest, I also do them because I sincerely believe that everybody needs a plan. If you've seen the conflict and the mess that can happen when a person hasn't planned, you'd believe that too. What I really want to do at these seminars is light a fire under everybody to get this done. This kind of planning is taking care of yourself, it's taking care of your loved ones, and it actually feels really good when you're done because this planning, it's not really about death. It's about life, your life, and the people that you love the most, and your legacy. So to summarize, if you'd like to claim that credit. You could schedule a life and legacy planning session, which you can do on my website. You can do with, and this little QR code would take you to the scheduling page on my website. I don't take very many of these appointments a month. Here's my upcoming availability. I do offer some evening appointments, and if you take one of those, please commit to keeping it because those slots are rare and valuable. Or if you need more clarification about a 2-hour session with me, you could also, through that website, schedule a 15-minute consult with me um, where we can talk and chat one-to-one. So I really appreciate you taking the time today to make wise legal and financial decisions for yourself and the people you love.